अच्छा
Who appeared?
Hello.
Sharanya appeared?
I am appearing on behalf of Ms. Sharani.
Lordship.
She assisted us very brilliantly.
Much
And many things we got to know with her able assistance. So we have ultimately concluded saying the appellant's submission that the gen set was complete and functional at the time of import, and the end use of both the imported gen set and the power pack is the same, that is, generation of electricity, is also devoid of any merit. There is a serious dispute between the parties as to whether or not the gen set at the time of import was complete and functional. Even if we assume it was complete and functional, that still would not help in driving home the appellant's contention. This is because the core end use of a subject article might remain the same pre and post application of the process, and yet it might have undergone a transformation into a different product. The contention of the appellant that the end use of both products is merely the generation of electricity is an oversimplification that conflates the core function of a product with its functional utility. The gen set at the time of the import was in a form that was suitable / intended for permanent installation. The process undertaken by the appellant imparts the core functional utility of portability to the gen set, a utility that was non-existent in the product at the time of its import. This is not a minor value-added feature. It is the defining attribute from which the final product derives its entire entity and character. This is how we have discussed. In the facts of the present case, both transformation test and the marketability test stand fulfilled. The process of placing the gen set within the steel container and fitting that container with additional integral components brings into existence a new, distinct, and marketable commodity. This process would thus amount to manufacture under Section 2FI of the Act 1944. Consequently, the appellant liable to pay excise duty on the goods manufactured. For all the foregoing reasons, the appeals fail and are hereby dismissed.
Obliged.
Obliged, Lordship.
May please, Your Lordship. Your Lordship, in August, Your Lordship, judgment reserved, written submissions filed, Your Lordship gave us 4 weeks time to settle, Your Lordship. 16th of August, we had, I'm for the financial criteria, Your Lordship.
Which is this matter?
This is the matter, Your Lordship, where against an admission order in NCLAT, the corporate debtor had come in appeal, Your Lordship, along with some home buyers, Your Lordship.
We have reserved the.
Yes, Your Lordship. Your Lordship will kindly have the order of 6th August, Your Lordship. I have reserved it. Your Lordship may read that. Appeal admitted, arguments concluded, judgment reserved.
Mr. Shyam Diwan?
Yes, Your Lordship. That's correct. Madhi Vidyaman, yes. Madhivan.
Okay. Now, what are the developments?
16th August, we had a meeting with the corporate debtor, Your Lordship. No concrete proposal was given. Your Lordship in para 9 said that if the parties are able to resolve.
What do you want today?
No, Lordship, Your Lordship will have to pronounce the order. That's all, Your Lordship. Because Your Lordship said that we gave only 4 weeks to settle.
Us that there
No,
is a CLC
no.
agreement and we have.
Lordship, may read para 9. May read para 9.
4 weeks.
May read para 9, Your Lordship. If the parties are able to resolve, we may not have to deliver a full-fledged judgment.
So you have not.
Not.
So we'll now proceed to.
Yes, that's all I'm requesting, Your Lordship. That I'm just intimating, Your Lordship.
Thank
File the written submissions, Lordship.
Written submission. If you-
Thank you.
May it please, my lord.
My lords were pleased to issue notice on 11th of August and had ordered us to deposit the entire penalty amount with this court. Immediately a day after that, my lord, on 13th, we deposited the amount. My lord had further ordered in para 6, no sooner the amount is deposited than the matter shall be notified for further hearing. That was for the purpose of provisional release of the goods, my lord, because the goods are of perishable nature and the
What is your request?
my lord, the request is for listing and provisional release of the goods, my lord, so that
Give some date. We'll take it up on that.
prior to the vacations, if my lords may kindly accommodate the matter, because my lords,
Which vacation?
the puja vacations, my lord,
The vacation
my lord,
prior to that.
deeply obliged,
With my lord's permission, may I mention one matter?
deeply
Your
obliged.
lordship has reserved judgment on this, your lordship. This is Nilesh Babra Bite versus State of Maharashtra. Your lordship asked us to submit written submissions. There are two written submissions, my lords. Earlier one may be, lords, this may be a final written submission we would like to
So
submit.
that has to be
Yes.
one set of submission
Yes.
schemes.
Yes,
This is the final
this
one.
is the final one.
Council number 3. Matrimonial matter.
Easier, Mr. Algebra always.
What
Development, what is the feedback?
Tell them to report at 11. We'll dictate a short hour.
Your matter, no. Rajesh matter.
Yes, sir.
Yes, ma'am.
O'clock, get the amicus also, whether we'll explain on order.
Your Lordship.
Request the amicus to be here.
Your Lordship.
We'll dictate a short order. We are still hopeful something good may happen.
You are in one, I think. Not your matter. This is some other matter of his.
I will
Yes,
inform
sir.
MCAS also.
Call up.
Your Lordship, I am mentioning item number 46, which is listed today. Your Lordship, I humbly request you the matter to be taken up today, Your Lordship, because on the previous date also it matter couldn't read. And it's of urgent nature because of the counseling has started for several states.
We'll try.
Your Lordship, humbly obliged.
Be pleased, Your Lordship, as per Your Lordship's direction, the petitioner is present today.
The respondent
And,
Marital life.
25 years, Your Lordship, 2010 marriage, and 13 years boy is there. He's studying at the place of.
15 years married, 15 years.
One at a time, sir.
Uh,
One at. The husband has initiated divorce proceedings.
Yes.
You want transfer of those?
Your Lordship, the earlier round of litigation, there was a settlement between the parties. And the petitioner withdrew her 498A case and DVC case and joined the husband. But she was not treated well, and therefore she forced to, again, she was sent back and she is at parents' house.
9 applications
Yes, Your Lordship.
for restitution.
Yes, Your Lordship.
You want transfer of those proceedings?
Only the transfer. And last time when Your Lordship observed, both parties are willing to live together.
So what is the problem?
And the one is there is no security for the petitioner, Your
Where
Lordship.
is that?
And all her gold jewelry was held up with the husband, Your Lordship.
They are from which state?
Andhra Pradesh.
Andhra Pradesh. You will understand English?
Yes, my lord, you'll
Sir.
understand. English also.
So what is the problem? You want your wife back now? Come back now?
Sir, actually, I put the case to come back
Ah.
from the day one, from till now, from last 1 year, they are approaching towards separation.
Oh, just a
The
minute.
elders and the.
You have one son, you all have one
I
son,
already have it, sir.
13 years old,
Yes, sir. It's 15 years.
15 years old. He is with the mother.
Yes, sir.
What is the problem? She doesn't want to go back.
Your Lordship, as per the last order, she joined the husband.
Then
She was kept alone in the upstairs, first floor of the house, and she was not even allowed to talk in the family in the ground floor. And finally, she lived for, and she was
what are
very,
you doing? What is your business?
Sir, we are into business of gold shops.
Beg your pardon?
Gold shop. Jewelry-
Gold,
jewelry-
gold,
Ah. You must treat your wife.
Sir, from last 15 years, the same was continuing. In court, they are admitting.
Who
to
else
come
are
back.
there? Who else are there in your family?
No one, sir. Mother, father, and me, sir. Only three, sir. My father and mother also senior citizens.
So why is she complaining? That
Yes,
you
sir.
didn't
She
treat
always
her
complaining, and even small
fine?
things she is
So-
complaining and
so
going
that-
back, sir.
That means you all will not be able to live a happy, peaceful marital life.
No, sir. Whatever I am trying from my side. Like.
Would you like to take one more chance? Is this the end of the marriage?
No, your lordship, she is willing to live with him, there no.
Live with him, na?
Yes.
He is nodding. Ask her properly.
So many times I came here and I did. అక్కడ నాకు security లేదండి.
She is not feeling secure at the house, your lordship.
Security లేదు.
There is no security for her life.
అవసరం ఉంటే security లేదు.
So what is the apprehension? She has a threat from whom?
Problem ఏంటమ్మా?
ఫ్రీడమ్ అసలు ఏం లేదు. వాళ్ళ పేరెంట్స్ ఏం చెప్తే అదే చేస్తారు.
Whatever the mother and
అదే చేస్తారు. ఏం చేయకుండా
he
Can I speak?
and
బాబు స్కూల్ టీసీ కూడా ఇవ్వట్లేదండి.
Lord, may I suggest?
your lordships on the last occasion, your lordships observed that there will be some security will be arranged
Many
so that
conditions.
both can live together. What your lordships observed on the last occasion.
ప్రాబ్లం అయినా
Putting so many leaves.
The parties are married past almost 25 years.
15 years. 15 years.
15 years. They have one son born in the wedlock, who is now almost 14 years of age. The matrimonial disputes between the parties led the petitioner wife to leave her matrimonial home. In the meantime, the husband preferred an application under Section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. The proceedings instituted by the husband are pending in the court of Family Judge Raigad, State of Orissa. The wife wants transfer of those proceedings from Orissa to any court.
Senior Civil Judge Sompeta, Srikakulam district.
The court of Senior Civil Judge Sompeta, Srikakulam, State of Andhra Pradesh. Full point. Before we proceed to pass any final order, we would like the parties to once again talk and try to save the marriage. We are informed that in the recent past, the wife joined her matrimonial home. However, once again, problems cropped up and she left the matrimonial home. The parties are present today before us. The husband is ready and willing to perform and discharge all his marital obligations. The wife is also ready and willing to go back to her husband, but she has expressed some apprehension. What we have been able to understand is that she feels insecure at her matrimonial home. Full point. Perhaps some counseling may bring around a happy solution to this problem. In such circumstances referred to above, we make a humble request to Mrs. V. Mohana, learned senior counsel, to act as the mediator and try to find out some viable solution to put an end to this matrimonial dispute. Parties to act accordingly. Sure.
School TC ever friends, TC ever.
So let the mediator talk.
School TC baga with
Huh?
That the son's school transfer certificate
Sir, already
to
they
continue
have
the-
taken
she was not-
forcefully and it's with,
is not given.
no, it's already there. It's already with them, sir.
Should we put an end today itself, or would you like to save the marriage?
She's
Try,
willing, Your Lordship.
Huh?
She is willing to save the marriage, Your
Okay.
Lordship, because earlier he filed a divorce.
then make an end.
That was with.
Make one last endeavor. Next matter.
Thank you, sir.
My lords, pursuant to, my lords, the applicant has been released on bail today morning itself, my lords. As far as the second aspect is concerned, that is with respect to the clubbing, my lords. Subject to what your lordships direct, my lords, it may be disposed of, application may be disposed of in terms of your lordship's original order. Because the trial is continuing separately in the same court premises, my only apprehension is with respect to the clubbing, my lords.
We are now concerned with FIR number
532 of 2016, my lords. With PS Ramnagar, Chandrapur, Maharashtra,
32 of
2016.
registered at
PS Ramnagar, District Chandrapur, Maharashtra, my lords.
district.
Chandrapur, Maharashtra.
Now you want this FIR to be clubbed with which FIR?
It has already been clubbed, my lords. The subsequent FIRs, if I may have page 15, my lords. There is a chart which I have.
July is the order.
Yes, my lords.
Now, three states were not strictly following this order. Chhattisgarh, Madhya Pradesh, and Maharashtra. Now he says, they in part they have cooperated, the particular FIR, most FIR, he only wants that the states, three states will also strictly follow the directive of the 13th July.
My instructions are that the FIRs are already clubbed. So,
Okay.
Anyway, if it is not, the prosecutor
Not-
will appraise the court
yes, yes.
and strictly follow the 13th July,
Yes,
also
yes.
passed by
My lords.
Justice Kanvilkar will not
Lord.
order.
The relevant portion is at page 26, my lords,
Yes,
of your lordship's order. If I may read out, my lords.
just a minute. The applicant before us, original accused, has preferred this application seeking the following directions / clarification. Quote them, EPC. Right?
Yes, my lord.
Which is that last order we passed.
On 12th of September, my lords.
Our order dated 12th September 2025 reads thus. Good. Day when the matter was taken up for further hearing, the learned counsel appearing for the applicant submitted that the applicant has been ordered to be released on bail in connection with FIR number 532 of 2016, registered with Ramnagar Police Station, District Chandrapur, State of Maharashtra. This was the only FIR in which you were not on bail, right? Now
I
you
was
will be-
granted bail earlier, my lords, principal FIR. However, the trial court was requesting for separate bail in the subsequent FIRs as well.
Okay. Now you will be out.
I have already been released, my lords,
Released.
today morning.
With the grant of bail in the FIR referred to above, the applicant is now released from jail. We dispose of this application with a direction. The order passed by this court dated 13th of July 2022 in writ petition bracket criminal number 40 of 2022 shall be scrupulously followed and abided. Right? State to act accordingly. With the aforesaid, this application stands disposed of.
Grateful.
Next.
Item number 3, my lord, I am seeking my lordship indulgence, my lord, to grant one time file counter. It is ready, my lord, I will file it, my lord. I have sent to the respondent number 2.
Because in this, my lord's paragraph 2, the state has filed a counter and said it requires reconsideration. They're not cooperating. After 82 was executed, bail was granted, anticipatory bail, 376 case. I don't, my lord, have any objection if
Ask my learned friend.
he wants to file a counter.
You want 1 week time.
Yes, my lord, in fact, I have sent the counter, my lord, it is ready, my lord, I filed within a week.
Mr.
Plaint Prakash.
Learned Counsel appearing for the state of UP.
No, respondent number 2, my lord.
Sorry, for the respondent number 2. Prays for a week's time.
Yes, my lord.
File his count.
Yes, ma'am.
Posted in the next week. One copy of the counter shall be served
Sure,
at the earliest. Learned Counsel.
I am so grateful.
State's already filed its counter, my lord.
Huh?
The state has filed counter.
I'm so grateful.
Mate, I beg to appear for the respondent in this matter.
I will be seeking a short passover in this.
Lords had indicated this for final disposal, but this is actually my file written submissions also. We filed written submissions also.
Put it on any NMD date, top of the board. Put it on,
Either before Diwali or after Diwali. which-
Lord, let it be before Diwali. 5 years we've been waiting. This man is about 80, my lord. Yes, it doesn't matter. He just wants his litigation over.
Very well,
Bring in
please
the
take,
flat.
preferably after Diwali, but I leave it to my lord, fellows, whatever. Your lordship will take some time on this matter, therefore.
There are 3 SLPs and a civil appeal.
There are 3 SLPs and 1 civil appeal. There are diverse orders. It's going to be a difference of 2 weeks
29th October, top of the board for
Of life.
final
Life.
disposal.
of life.
29th.
Grateful.
Item number? What is this by? Who appears in this by?
My lord, item number?
Yes, Mr. Bhattacharya. What is this petition about?
Sir, I filed a miscellaneous petition for setting aside and was the order of the register.
How do we set aside our own order, Mr. Bhattacharya? What type of prayers are this?
Sir, I filed this writ petition under Article 32 for violation of my fundamental rights and for reinforcement
of my fundamental rights, my lord, which has been violated by a order dated 25/10/2010 in
The entire litigation came to an end. Right
lord.
from High Court, this court, now again you want to reopen it? Rightly not registered by the registry. Absolutely. Dismissed. Next matter. Is the amicus here? Let him come, let him. Once he is here, we'll pass. Next matter. There's a delay of 802 days.
Your Lordship, I am freshly engaged in this matter. I have received the file in the morning. Therefore, I pray for
802 days. Dismissed. Next matter.
Your Lordship.
There is a gross delay of 802 days in 5.
Your Lordship, we have filed an application for the vacation of that ex parte stay order.
It's all right.
But
Next
that application is still undisposed. Therefore, I request Your Lordship to kindly grant me some time, please, Your Lordship.
No, 802 days. Next matter.
My lords, it's a
Your
amendment.
Lordship, there is already an application under 39(4) is pending before the Honorable High
Who
Court.
have come, like, after so many years against a injunction order that you pursue there. This order, you can entertain 802 days, no explanation also.
My lords, kindly appreciate here, my lords, the amendment application was filed at the fag end of the trial. I mean, D1, D2 was examined, my lords. Then they changed the course of the plate for the further cross-examination at DW2 and 3. The petitioner felt that in case if the court comes to the conclusion that petitioners are not entitled to the main relief, therefore sought for an alternative relief, my lords. And from the pursuit of the contents of the affidavit accompanying by the application, my lords, sorry. The mail relief is was suit for declaration, my lords, declaration and position. Now they filed an amendment. If court comes to a conclusion that I am not in position and put me in position, well, the entire I led the evidences that they are not in position. And my DW1, DW examination had taken place. PW was examined. Cross examination is entire done, my lords.
You don't need to lead fresh evidence, right? His new plea will be decided on the basis of the evidence that is already led.
But my lords, the amending
It doesn't change, it doesn't alter the entire character of the suit.
my lords, in this case, my lords,
Matter.
highly obliged.
Excuse me. Please. My lords, unfortunately, certain documents which needs to be placed in this matter have inadvertently been left, my lords. I request if this matter be adjourned for a week so that I can place those documents. Those are vital, my lords, for the...
Those documents.
My lords, I'm sorry.
Do you really need those documents?
Yes, my lords, the original order of the civil court, my lords, it's in my favor. That's not been placed. Only the decree has been placed. The judgment has inadvertently been left. One, my lords.
According to you, it is barred. Suit is time barred, right? That's your principal
No,
argument.
my lords. My suit is within time. The opposite parties defendants' cases that's time barred. My was within limitation. And my lords, another testimony, my testimony as a plaintiff before the civil court has not been placed on record. That is very vital. Therefore, my lords, the High Court has reversed the judgment of the civil court. And I have won from the civil court. High Court reversed against me. Now I am before this court. So my testimony and, my lords, the original order judgment of the civil court, which is in my favor, has to be placed on record. I'm very sorry that they have not been placed on record inadvertently. I just request, my lords, if it can be, my lords, adjourned for a week so that I can place them with the application for additional documents. Because, my lords, without that, what High Court has come to the conclusion, I don't have any ground to, my lords, assail those reasons of the High Court's order. High Court says that the...
Actually,
Highly obliged.
keep it after 4 weeks.
Highly obliged.
Please, your
Please,
lords.
was the question here, my lords, is
9 Monday. Monday.
Very well.
It came in the morning today.
Very well.
Lordship pleases. Grateful.
May it please, my lords have dismissed similar matters.
Yes,
Hence dismissed. 11 is Tola, my lords.
Ola.
Very grateful.
Your Lordship may grant a pass over, arguing counsel is on his way.
Malas in 93.
Concurrent finding.
I'm sorry. I see,
Concurrent
yes, the
finding.
concurrent finding was to kindly see my lords. In 93, Ramabhai Patel, Vinubhai Patel, and Namneet Bhai sold through power of attorney to.
You are getting easy now.
So, my lords, my full submission is.
One paragraph 23. Come straight.
Yes.
Straight. Say something on this.
Yes. So, my lords, my claim is, first of all,
Not on facts.
Yes.
Only on law.
Only on law. My lords, his claim is that there was an agreement to sell in 87, finally a sale date in 2001. That's his claim. In the suit, there were two issues framed, my lords. As far as my issue was issue number 1, where was decide against me. His was that whether the defendant has a right, my lords. That also was decided. So who has a title? No one knows.
Show us the power of attorney. Come on, give it to us.
My lord, that's not.
This is next matter.
My lord, just kindly appreciate, my lord.
Next matter. You run. You have a better matter. You have better matters.
Very unlikely.
May it please, my lords. Because before I say anything on the merits, there is a delay of 366 days, but there is a delay for a genuine reason, my lords. And as on the same issue, your lordships already entertained a petition where it was held in my favor. The findings which have gone against, there is a contra decision of the Bombay High Court, which took a view in my favor. Your lordships have entertained the SLP.
Issue notice on both delay and the main matter.
Lordships. Okay.
And tag it with that.
Lordship.
Yeah.
I'm sorry. Yeah, please, Your Lordship. Lordships, the High Court, my lords, comes to a conclusion, my lord, based on a document, my lords, which was never before the High Court, my lords. My lords, there are two agreements, my lord, which are entered into. The 2019 December, where 1 crore was given.
Section 69 section 2 will come into play here, na?
My lords, that is what, my lords, I'm saying, my lords, that the main document basis by which this conclusion has been arrived at, my lords, that agreement was not there before the High Court. Because there was a second agreement, my lords.
Section today is of maintainability.
My lords, there.
Right.
Therefore,
We are debating on 69.
my lords.
Go through this judgment and come back in the next week, next month.
Well, it's we have quoted this judgment, my lords. Now
You are relying on this.
my lords, I am, my lords.
Is it helpful to you?
My lords,
It is going against.
my lords, I am saying, my lords, is helping me, my lords.
It's not helping you. It's not helping.
Before this, my lords, before coming to this, my lords, I have something prior to this, my lords.
Right.
My lords, even to come to a conclusion where it is in the course of business or not, the main document has to be seen, my lords. That document, my lords, was not before the High Court. That is, my lords, my argument here.
Produce that document.
My lords, that was to be produced by them, my lords, because they had instituted the case. They lost before the lower court, my lords.
So what is your exact argument? What is your exact argument?
My lords, my exact argument is that, my lords, number one, before coming to a conclusion that I fall within the
Para 25.
25 minutes of my appeal, my lords?
Impugned.
Impugned, my lords.
Read it.
My lords, in view of the judgment of the Supreme Court in ship developers, the principles laid down that if the right sought to be
right sought to be enforced arises from a contract which is not entered into in connection with the business of the unregistered firm with a third party, the bar of 69(2) will not apply. In the instant case, the business of the first plaintiff firm is real estate development, and the money in question was not given to the first defendant for the said business, but was in the nature of a financial assistance. Therefore, the bar under 69(2) would not apply, and the suit filed by the plaintiff is not.
I am only saying, Millets, to come to conclusion like this, Millets, the second agreement or MOU had to be before the High Court, Millets, to see whether 69(2) would apply or not.
In the absence of that document, what do you expect the court to do? Reject the plaint on the premise that the suit is not maintainable because of bar of 69(2). You can raise this point in the course of the trial. Dismissed. Next matter.
Grateful, Lord. Great.
Yes.
May I please, my lord? Lord, the lordship is aware that this is with respect.
Why are you challenging this after succeeding?
My lord, for a reason, my lord. Only limited aspect, my lord, before the lordship is with respect to the constitutionality, my lord. No, my lord, revenue will certainly come before the lordship, my lord. And at that stage, I will have a problem because
Issue notice.
obliged, my lord, deeply obliged.
My lords, an insolvency petition has been filed against me to cancel the sale deeds. My lords, I have produced an IA in the trial court for protection of the documents that got dismissed, my lords. Challenging that, I went with CRP. There also it got dismissed, my lords. Please see para 6 of the CRP order, my lords. Page number 6. On a perusal of the material on record, this court observed that the petitioner has not filed any petition under order 8 rule 1A3 with regard to receiving of documents with condonation of delay. My lords.
Come to para 6. Come to para 6 of the.
Further, the petitioner has not provided any explanation for delay in filing the petitioner.
Para 6 of the impugned order. Page 6.
I am reading that only, my lords.
On a perusal of the material on record,
this court observed
that the petitioner has not filed any petition under order 8 rule 1A3 with regard to receiving the documents with condonation of delay. Petitioner has not provided any explanation for the delay in filing the petition for receiving the documents. Now, this is something important. You have not mentioned anything about the documents in the counter file before.
My lords, that were later found out, my lords.
Father and daughter.
Obliged.
Letter?
Yes, your lordship. I'm the proxy counsel on behalf of petition, your lordship.
Agent.
My lord, it is admitted fact that the deceased had died intestate, and so Hindu Succession Act applies. And also, it is admitted fact that deceased was the son of appellant, because of which she is class 1 here and is entitled for the share in property.
Come to para 90.
9 of.
Just read from the 5th line. You are the plaintiff.
Yes, ma'am.
You instituted the suit.
Yes, ma'am.
Defendants didn't appear.
Yes, ma'am.
Suit dismissed.
Defendant appeared, ma'am. I didn't appear in the examination as a witness.
So defendant didn't appear in the appeal.
And he didn't appear.
Come to para 9
of
the impugned order.
Yes.
Read the 4th line. The burden of proving the issue
framed on the burden of proving the issues framed by the trial court was on plaintiff, but she could not appear because she died, my lord.
Continue now.
Yes,
the grounds
taken by plaintiff in her plaint and documents relied upon has not been produced in evidence.
What is the High Court trying to convey? We couldn't understand. What is it trying to convey? The grounds taken by the plaintiff in her plaint and the documents relied upon have not been produced in evidence. plaintiff was given several opportunities by the trial
Trial
court to produce evidence in support of the facts mentioned in the.
Yes,
Then who appeared on behalf of the plaintiff?
nobody appeared, my
So
lord.
how do you expect the court to decide the suit? On the basis of what?
Yes, my lord.
Tell us, sir. Dismiss, next matter.
My lord, may kindly.
Yes. What's your good name?
Mayank Kumar Chaudhary.
Heard Mr. Mayank Kumar Chaudhary, the learned counsel appearing for the petition. This is a litigation between mother-in-law and daughter-in-law.
Yes, my lord.
Ajit Kaushal comes as LR of
Yes, my lord, or of
his
appellant.
mother.
Of
Your
appellant.
case is the mother's share
Yes, my lord.
from the son's estate
Yes, my lord.
should come to him also.
Or section 15 of Hindu Section Act.
But you should not, as brother said, nobody got into the box. But only the
When did the lady die?
Died on 1st of February 2018.
1st
Of
February
2018, when appeal was pending, my lord.
That's the thing.
nothing.
Since this is a dispute between family members, we want them to sit, talk, and try to reach to some amicable settlement. Right? Parties are issue notice.
Yes, ma'am.
Take the note.
All right.
Delay gone.
May it please, my lords. My lords, Heir, my lords, has succeeded before the trial court, my lords. The suit was decreed, my lords, for 13 lakh 50, reduced to 2 lakh 82, my lord. What the High Court says, you have not given the number of hours, my lords, but he's here. But my lord, there's a detailed reason. My lords, can you refer it to mediation if something can be worked out? This I was just.
This causes a lot of embarrassment.
I know that. I've told him, my lords. Leave it to my lords.
Dismissed.
Lords, this is also Tola.
Tola.
Very grateful.
You know, this is a case where the petitioner was unrepresented before High Court because the earlier counsel who has handed over the files to the client could not intimate him about this particular petition. So he was unrepresented. My humble submission that he may be allowed to represent before the High Court and put his case on merit.
Come to para 9.
In view of the aforesaid backdrop, the admitted position that the appellant plaintiff is the owner and landlord of the premises in question, the subject property is of commercial nature and had been let out to the respondent with effect from 1st November 2017 in terms of registered lease deed. That is fine. I have challenged 10. It is manifest that the respondent has failed to vacate the tenanted premises despite service of legal notice dated 30th October 2020. The appellant plaintiff being the owner as well as the landlord of the subject property is entitled to reap the benefits of his property and derive rent plus damages means profit for the wrongful occupation of the said premises by the respondent.
Now 11, 70,000 rupees per month from 17 to 20.
My lord, my case is this, that I have challenged this
You have
lease deed.
deposit 92,575.
Yes, it was an order.
From 1st of March and at the rate of 1 lakh for each successive calendar.
My lord, my case is this.
You want to stay back? You want to retain the possession?
I'm in position being, I have paid the part consideration amount.
Comply with this. Dismissed. Next man.
The issue is pending, my lords, in Ojas Medicare. Big batch of
Tag
matters.
it.
Very good.
May please, Your Lordship.
Lordship, it is not only my case, it is even the respondent case that your Lordship, I was in the position from 1987. The Honorable High Court in paragraph number 26, your Lordship, it's made a completely contrary observation.
Para 21.
Yes, Lord.
Balasingham.
Yes, Lord.
Balasingham
Yes.
was the owner of the property.
Balasingham is the original owner of the
Right.
property. Yes, Lord.
Now, Balasingham purchased from Muniamma,
Muniamma.
which is evident from Exhibit A1.
Right, Lord.
Sale deed of 528.
Yes,
No
Lord.
problem.
No.
Balasingham availed housing loan also by executing a mortgage
Yes, Lord.
in 1982.
Yes, Lord.
And the parties are Christians.
Yes, Lord.
So they are governed by the Indian succession.
Indian succession.
Balasingham was survived with his wife, Mani Kavali, and Mrs. Mary Subaratna. The problem is,
Yes, Lord.
what is there to indicate that Mrs. Hilda is the widow of Balasingham?
Lordship, there is a Right to Information Act we have applied to your Lordship. The Right to Information Act at page number 115, your Lordship, it is mentioned that she is, and even otherwise, your Lordship, even otherwise, your Lordship, it is kindly see paragraph number 26 of the impugn order. It says that admittedly there is no evidence on record as to when the defendant came into possession. I have a categorical finding of the trial court, your Lordship. Even it is the plaintiff's case that came into the possession in 1987, your Lordship. I'm in continuous possession from
If you look
2023.
at para 27,
Yes, your Lordship.
but for the fact that you are not governed by Hindu Succession Act,
No, Lordship,
even the
Lordship, I'm not entitled.
children will have.
Lordship, I'm not entitled. Even otherwise, your Lordship, I'm eligible under the adverse possession, your Lordship. No, adverse possession, Lordship, adverse, kindly consider this adverse possession, Lordship. It is admittedly, I'm there in possession since last 23 years, your Lordship. It was not disputed by the plaintiff. And in fact, the plaintiff's vendor has not disputed that she was never claimed this possession. She never claimed this at any stage of arbitration.
That's it. Dismiss. Next matter.
Obliged.
Item 25, my lords, I am aggrieved by the finding of the High Court at page 3, paragraph 4, that it is the admitted case of the plaintiff that B scheduled property is the absolute property, my lords. I straight away invite my lords to page 46, plaint, my lords. Page 46, my lords, Roman 5. It is the specific averment that the ancestral joint family properties of Natesa Padayachi were divided.
Who are you?
I am the daughter of the alienor, my lord, daughter and son.
Your case is that this is an ancestral property.
Yes, my lords.
Right? Now come to para 7, ma'am.
Yes.
Come to para 7.
Yes, my lords.
The first question of law may
Yes,
be
ma'am.
applicable to a case where the father alienates the property of a minor without the permission of court.
Yes, ma'am.
In the present case, the suit property is not
The joint family property.
to which plaintiff should claim any right.
As-
Show us that this is a joint family property.
My lord, straight away then defendant's admission, my lords, at page. The first defendant's admission, my lord.
Now, let us complete the reading of the entire para 7.
83.
Yes.
And 8 both.
8 also, assuming it is joint family.
Yes, my lords. Assuming for a moment that the suit property was sold for any immoral purpose.
That is also established.
Yes.
I will take my lords through 3 pages only. If my lords are not satisfied, I will not press any further. First page 21, my lords, annexure P1, which is the partition deed under which money gets this property.
Who contested the suit?
The purchaser, my lords, alienee under the sale deed by the father.
This sale deed is of which year?
79,
At that time, your client was aged
2 years.
2 years.
And P2 was in the womb. He was a child in the womb.
Right. Now, therefore, You are the plaintiff.
Yes, my lord.
It is your case that this is a joint family property,
Yes, my lords.
right?
Yes.
The burden is on you to establish.
Yes, it is admitted by defendant one, my lords. My lords may kindly come
Wait a
to page
minute.
83.
Wait, page?
83. Deposition of DW1, my lords. He admits.
Who is DW1?
He is the alienee. He is the sole defendant in the suit. Cross-examination at page 83, top of the page, my lords.
Any PDF?
PDF page.
Annexed.
This is the deposition, my lord. This is Annexure P5.
Internal page?
Internal page 65, my lords.
Which part you want to read?
This is cross-examination of the defendant on 25607. In the SLP paper book, my lords, top of the page, my lords. I do not know that the second plaintiff was pregnant while I was purchasing the same. It is correct if it is stated that the suit property was the ancestral property of money. He admits categorically, my lords.
So will this admission be sufficient to allow?
My lord, Section 58 Evidence Act, my lord, admitted fact need not be proved, my
You
lord.
show us something that this was not a self-acquired property of money. Money acquired, money derived it from his father.
Then again, page 21, my lords, partition deed. Under which money gets this property, my lord, Annexure P1.
Okay, let's for the time being proceed on the footing. It was a joint Hindu family property.
Yes, my lords.
Co-partnership property.
Yes, my lords.
In partition, money got his share.
Yes, my lord.
Well,
yes,
if money got his share in the partition between other co-partners,
yes,
whatever share he derived becomes his absolute.
my lords, but by then P2 was a child in the womb. He is a son. He becomes a co-partner. He has a right by survivorship. Even a child in the womb has right by survivorship, my lords. Yes, my lord.
The thing is, appellate court says it was for legalness.
There is burden is not cast properly, my lords. My lords are quite well aware.
You notice.
Grateful, my lords. Very grateful. There is 133 days delay, my lords. I'm so sorry. I should. Thank you. Grateful.
Yes. Yes. We are still hopeful.
My lords, something cannot be there. Come to some point, it's the merging point which is eluding all of us.
We have been hearing this matter past almost 2 days. We have devoted much time in this matter as we are hopeful that we can save the marriage between the couple, between the parties, and more importantly, thereby we can secure the career of their minor daughter, Ahana. Ahana is 5 years of age as on date. Yesterday, in the course of the hearing of this matter, we thought fit to speak to the parties individually in our chamber. We first had a talk with the husband and thereafter with the wife. What we have been able to gather after hearing both is that the husband has love, affection, and respect for his wife. And in the same manner, the wife also wants to save the marriage and reunite with her husband. However, few hiccups, or we may put it, the usual wear and tear of the marital life took a heavy toll on the parties. This led to a lot of bitter feelings between them. Ultimately, the wife decided to leave her matrimonial home, and she is now residing at her parental home in Vizag.
Vizag, Vijayanagar.
Vijayanagar, state of Andhra Pradesh. The husband is a practicing advocate. Earlier, he used to reside in Vizag. However, for his better professional prospects, he decided to shift to Hyderabad. Now he is practicing in Hyderabad. Ahana at present is with her father. Ahana seems to be a very bright child. She appears to be very talented, participating in a lot of extracurricular activities. And what we have been able to understand is that if she is able to perform well in some event, she may get into the Guinness Book of World Records. At any cost, we want the parties to reunite and save the marriage, at least for Ahana. Next. The parties have been able to reach to a consensus that the wife will come down to, to some consensus. The husband has agreed to provide reasonably good accommodation in Hyderabad for his wife to stay. The husband will start looking for some rental premises. And once he is able to identify 3 or 4 or 5, he would immediately inform his wife to come down to Hyderabad and have a look at those premises. Ultimately, it is for the wife to take the final call as regards the rented premises. Wherever she deems fit and proper, she may go for that premises. The rent will be paid by the husband. Above all, what is important for us to notice that the husband has assured us that he will take due and proper care of his wife in all respects. They may not be able to start living together all of a sudden because of the friction that has taken place. But we are sure with passage of time, the differences between the husband and wife may be buried, and one fine day they may all start residing together as a happy family. Right? In such circumstances referred to above, the husband shall now proceed to search for a good rental premises. Once the premises are identified, the wife will travel down to Hyderabad, have a look at those places, and then come and settle in the house so that she can spend time with her daughter Ahana. तो ये लास्ट लाइन निकाल दो बस रहने दो The husband has also agreed that he would bear all the expenses for the maintenance and better living of his wife. Okay? Post this matter, Ahana may spend time with both father and her mother, with some distinct understanding between the parents.
Maybe brother spent a lot of time, 45
My
minutes.
lords, this is a classic case where we learned, my lords, as counsels, the effort and the time given by a constitutional court, my lords. I mean, the human side of this court, at least from my side, for the first time, I'm seeing something of this nature happening.
There is human side in the constitution on that. We owe it.
Exactly.
We owe it.
Daughter will join the.
We are grateful to the learned amicus for all the efforts he has put in so far. We express our gratitude towards the learned amicus.
Obliged.
We also request the learned counsel appearing for the parties to make all possible efforts till the last to ensure that the marriage is saved and the parties start residing together as one happy family with their daughter Ahana. Posted after 5 weeks? 5 weeks? 6 weeks?
Post Diwali.
8 weeks. The further progress in the matter shall be reported on the next date of hearing. Since we have devoted a lot of time in this litigation, we treat this as a part.
In the meanwhile, that guardian ward's petition is pending, that may be.
That will be. In the meantime, all proceedings between the parties shall remain stale. Right?
Obliged.
Fine.
Sir,
Obliged.
he herself felt that this is the better way to put it.
Yes, madam.
He felt that husband's help will be needed to look after.
Definitely.
So let them arrange how to look after. That is, you are asking for exclusive custody.
The daughter will join once the mother will.
They have decided to have, mother also felt the conversation that she will need the father's help to look after the daughter.
Right.
So we are not saying anything about exclusive now. They will arrive at some arrangement.
They will definitely, after this, they show definitely maturity. Some understanding would be there, my lords. Shown.
Obliged.
Deeply obliged, my lords. Deeply obliged.
Great.
Next.
What's the sale deed of 2004, my lords, challenged in 2022 after 18 years. That's also on the, and the challenge is on the illusory cause of action, my lords. High Court dismisses my revision, 711 and revision on the ground that the limitation cannot start from the date of registration. That's the finding of the High Court, para 17, page 25. As your lordships has held it that registration of a sale deed would be a constructive notice under section 3. Uma Devi, your lordship, who couldn't trust.
Tatvam Patel is an expert in this subject.
My lordship.
He knows that this has been explained by the Patel, gone through Justice Qureshi's judgment. There he said that don't go only by the constructive notice. Sometimes you have to take a practical view of the matter. Party may not be aware. When you apply constructive notice, that is by a deeming fiction of law. But there may be cases where party.
Here, my lords, may I submit, my lords? Here he says, my lords.
Show us something.
Yes.
Forget about the constructive part.
On suit, my lords, may have.
Show us something.
Yes.
That he was aware of it.
My lords, may say have page, his everments, page 10 and suit, my lords, may I just take your lordship to suit, my lords, his everments. It's first, my lords, may have page 60.
Okay. Have you gone through the recent pronouncement of this court authored by Justice Narasimha on constructive notice?
That's the Dali bench judgment, my lords. That thereafter Uma Devi has been pronounced by Justice Dhulia. That's Dali bench.
What have they said about this constructive notice?
Yes, my lord. This is Uma Devi.
If we have to strictly go by the date of registration, then the suit is barred.
Lordship, please. Lordship, please. So, your lordship says.
You are questioning the sale deed on what ground?
No, they are questioning. I am not questioning. They are questioning. I am the defendant.
Sorry, you are the.
They said I had my right, which my predecessor's name has not been entered into the records in 1988. That is what their claim is, and that continued till registration of sale deed.
their predecessor's name was not entered into revenue records. That is their claim since 88.
You tell us.
Yes, my lords.
Who executed the sale deed?
My lords, his family members, the plaintiff's family members, his uncle is
Who was the original owner?
the grandfather, his grandfather.
It's an ancestral property.
It's an ancestral property.
No partition took place.
But that's the, in 88, prior to, because then in 88, when there was a mutation happened after the ancestral death, his name was purposefully left out. That we are not aware as to how it has been left out, because we came into picture in 2004 when we purchased. His name was purposefully left out. Therefore,
But why does High Court say that no cause of action is been?
therefore, may I request my lords to see that para 10 of the cause of action paragraph. If in the suit, my lords, page 67.
Annexure?
That would be, I'm sorry, my lords, just a minute. Annexure would be, P2 is the suit, my lords.
Beg your pardon?
Annexure P2 is the suit. And then in cause of action has been mentioned in para 67, page 67, para 10.
Annexure.
P2, my lords. Annexure P2 is the suit. Internal page 67, it's a cause of action. May I read the cause of action portion first, my lords, and then we'll take to his averment.
Paragraph?
Paragraph 10. The reasons for filing of the suits arise. Am I with my lords?
Yes.
Arise since the grandmother of the plaintiff Jasoda Ben Bhagwan Das died in 15/4/1987 without executing will codicils. Since the father of the plaintiff Kanubai Umayabai Sankar died in 88. Since the defendant assembled and in their collusion created false documentary evidence like Pedhinama, the reply of third party application, and on that basis they have got entered mute and executed sale deed in 2004. So his name was left out in 88 itself.
What was the age of this?
He became major in 85. The plaintiffs.
What is his name?
Sanjay and Jatin, the plaintiffs, Maharaj.
And who is this Kanubai?
Kanubai is his father.
So after Kanubai passed away,
Yes.
in what manner the revenue records came to be corrected?
Nothing has happened.
Kanubai's name was never reflected.
Was never reflected.
Why?
Because
Kanubai doesn't have a share in this process.
it appears that partition might have taken place prior thereto. We are not aware of it. We came into picture in 2004, but in revenue record since 88, it continued.
For
Purchaser, 2004. Sale deed registered.
And the suit came to be instituted in
2022. 2004, it was registered. Possession handed over. I am in possession.
In the meantime, the further proceedings of, is it a regular
civil suit, Malos?
regular civil
Page
suit number?
56. 436 of 2022 pending before Principal Senior Civil Judge Ahmedabad Rural.
Shall remain state.
I'm sorry.
Give them dusty.
I'm sorry.
May it please, my lords.
My lords, there are two orders in the challenge over here, my lords. First is the amendment petition that we had filed regarding amendment of pleadings that was rejected because saying that there was a delay and delay was not explained. But we had brought forth the pleading that there was a fraud committed on the end and the vendor had no title or possession or right to sell this property. Second, my lords, we had filed a second appeal, which the Honorable High Court has stated that because a suit and a counterclaim was filed, two appeals were supposed to be filed and not one appeal. Our argument was because it is a consolidated decree, so therefore, my lords, one appeal was maintainable. My lords, there are 5 High Court judgments. 3 are saying that to a composite, a single appeal can be filed. While
Type of amendment you wanted?
my lords, what had happened was the property, the vendor, he had no title on the property that he sold.
The suit is at what stage?
My lords, the suit has been disposed of. The appeal has been disposed of.
Right.
We went in the second appeal now. And in the second appeal, when we came to know about this fact, that was the 1954 judgment that I've annexed with the petition. My lords, I filed an amendment petition. That amendment was rejected because
Amendment of what?
of the my written statement before the trial court, my lords. We stated that because the vendor had no title, so therefore we stated that as he had no title.
Second, that it's lazy files now. Example.
We'll keep it on Monday. Somehow we have missed this one.
Obliged, ma'am. My lords, the suit came to be allowed, the counterclaim came to be dismissed. There we have to be filed a single appeal against both the orders.
Right.
The appellate court confirmed it. Now what happened was when we went to the High Court in second appeal, the High Court stated that because you have not filed an appeal against a counterclaim, you have to file 2 appeals.
Correct.
Therefore, the res judicata comes into play.
Correct.
But my lords, our argument was that because it was a consolidated decree and a consolidated judgment, therefore one appeal is maintainable. My lords, there are different.
Do with your plea to amend the written statement.
No, my lords, but there are 2 orders that have come into challenge. I have challenged both the orders because both the orders were passed on the same day. So therefore, I have to challenge both the orders, my lords. Yes, my lords, but it was as it was pronounced separately, so I had to challenge both the orders together, my lords.
But you come to this page 6. Just read this finding.
My lords, point 7.
Page 6, internal page, filed a suit being title suit number
58 of 93.
Same was decreed by declaring the title of co. This decree never came to be challenged till date and as such has become final. As argued by Mr. So-and-so, has not placed anything on record to show why the proposed amendment was not sought to be introduced earlier and is being attempted to be done at this belated stage. Any good reason for
My
us
lords,
to-
our argument was that we did not discover this judgment of 1954, where this property was owned by the Raja of Patia. He had purchased it through an auction proceedings, and therefore he had the right title and interest over
And
the
on the strength of this, how will you defeat the claim of the?
My lords, we were saying that because he had no title, therefore the entire sale has to be cancelled. Whether it's for us or whether it's for them, the entire sale has to be cancelled
You
because
don't get anything.
No.
Plaintiff doesn't get
No, my
anything.
lords.
Then land goes to whom?
to the estate of Raja of Patia, my lords.
Next Friday.
My lords, next Monday or Friday?
Friday.
Obliged, my lords.
Yeah.
My lords, in item number 28, I beg to appear on behalf of respondent number 2, my lords. My lords, this is a MA suo motu which has been taken up by the court, my lords, for the depositing the amount.
So who appears for the petitioner today?
I'm for the petitioner, my lord. We
Have
had
you
already
deposited
deposited.
this amount?
Yes,
5
it's long
lakhs?
back, my lord. It is the respondent number 2 has not been providing the account details. That is why the amount could not be transferred to the account of the respondent number 2.
And who appears for respondent number?
My lords, I appear on behalf of respondent number 2, my lords. I appear virtually. I apologize that I.
So why are you not providing your account details?
My lords, we have been trying to establish contact with the client, but unfortunately, the number which we had is not available, and my lords, person is a very old man, so I'm not able to establish any contact. In fact, I had informed the local council as well.
Supreme Court Special Lok Adalat. The following order was recorded, dated 29th of July 2024. Spoken. Sorry, this matter has come up before us today with the office report stating that the amount of rupees 5 lakh deposited by the petition in accordance with the settlement terms is now to be dispersed and released in favor of the respondent number 2, Jitendra Bera. But Shri Bera till this date has not furnished his account details or has not come forward to claim this amount of rupees 5. Mr. Shivam Kumar, learned counsel appearing for Mr. Bera, would submit that he has no instructions from his client. We grant one last opportunity for the respondent number 2, Jitendra Bera, to furnish the necessary information as regards his bank account book. Post it after 2 weeks.
Grateful, my lord.
May it please the Lordship, my lord. The two appeals, my lord, there's a delay of 177 days, my lord. That is enumerated in page 185 of, my lord, one of the SLPs, my lord.
How do you propose to invoke arbitration?
My lord, on the
Signatory to the main agreement itself?
Yes, I admit. Now, what I say is, my lord, that, my lord, the agreement was entered upon between the firm and the PPCL, my lord. There's no dispute with regard to, my lord, me being a partner, which is another agreement which I seek specific performance in a separate suit, my lord. I'm not seeking any relief with regard to that, my lord, against BPCL, my lord. Nobody is disputing. I'm sorry, my lord.
Page 4.
Yes, my lord. Of the impugned order, my lord. Yes.
Read the third paragraph. This court has to decide. Read it.
Should we seeing, my lord, section 11, appeal from section 11, my lord, or the appeal from section 37, my lord? There are two appeals, my lord. One is from section 11 application, my lord. This other one from the division bench, my lord.
No, we are reading this order of the High Court. Dated 27th.
That's a single bench judgment. Yes.
So just come to
Yes, my lord.
Page 4.
Yes, my lord.
Internal page 4.
Yes, my lord.
The third paragraph. This is what we have understood. This court has to decide whether the petitioners, non-signatory to the memorandum of agreement,
Yes, my lord.
dispensing pump and selling license dated, can invoke the arbitration clause and approach this court for appointment of arbitrator in terms of clause 19 of the said agreement.
Yes, my lord.
Then it says further, it appears that there was an agreement between the petitioners and partners of Ambika Service Station. When the petitioner came to know that another undated agreement had been signed by the partners with a third party, a suit was filed. This is all okay. Internal disputes.
Yes, my lord.
But then, how do you say that I have a dispute with BPCL and therefore appoint an arbitrator?
No, my lord. My right with regard to, there are two things, my lord, needs to be taken into account, my lord. I was undisputedly in control of the business from 2015 till 2022, my lord. For 7 years, my lord, there are documents, my lord, when the application under section 9 was allowed, my lord, and yes, my lord. The agreement between the partners or the agreement between BPCL? BPCL, yes, my lord.
Today you want to drag BPCL into arbitration.
Yes.
Take us to that.
Yes, my lord. Lordship will kindly take, my lord, the page 27, my lord.
Sure.
P1, my lord.
Now just say.
I'm sorry, my lord. P2, sorry. I'm sorry, page 33, my lord. I'm sorry. P2, page 33, my lord. That's the licensing agreement.
It is between
Bharat Petroleum, yes. Yes.
and
In the my lord, in case of a firm, I'm on 2, my lord, and 1 in case of an individual, I'm not on that, my lord. I'm on the other one, my lord. In case of a firm, the present members of the said firm and any other members or member for the time being of the said firm there and each of their heirs, executors or administrators. I'm on this aspect, my lord. There, my lord, may I hand over one copy, my lord? There's the original one, my lord. While typing it out, my lord, the handwritten portions were, my lord, omitted, my lord.
who signed this agreement?
Agreement was signed by the erstwhile the respondents in the suit, my lord, who are the original partners, my lord. We were inducted in 2015, my lord. We were inducted in 2015, my lord.
Who inducted you?
My lord, the original partners, not BPCL.
BPCL recognized you at any point in time.
That was the original dispute. That was no.
That's the end of the matter.
No.
That's the end of the matter. Then how do you say that I want to go for arbitration?
Well,
Dismiss next matter. Next matter. What is this?
Lordship, this is a 302 criminal appeal. Trial court has convicted for life to 3 accused persons. High court reversed it and acquitted them.
On what ground?
Lordship, the High Court says that the statement of the injured, there are 4 injured eyewitnesses. Grateful.
Wait, please, Your Lordship. I appear for the petitioner state. The Honorable High Court against the appeal against conviction under 302 converts it to 304 part 2. However, the findings are contradictory. If Your Lordship sees page 38.
What are the injuries?
Injuries are at page 35.
Annexure?
It's in the impugned order itself, Your Lordship. Page 32.
What is the weapon used?
Iron rod.
Which part of the body?
Head.
How many blows?
1 blow.
The genesis of the occurrence? How did the incident occur?
So, Your Lordships, these, there were 4 family members.
You said page number?
Page number 32 are the injuries that are reproduced by the Honorable High Court.
Internal page?
Yes, Your Lordship. SLP paper book, page 32.
Okay, come to para 34.
Yes, Your Lordship.
Dr. Sachin.
Yes, Your Lordship.
Conducted the postmortem.
Yes, Your Lordship.
Obliquely placed linear sutured wound, so and so, so and so, so and so.
May I only submit, Your Lordship, there is no dispute about the incident as such. The Honorable High Court converts it, saying that, I'm sorry.
Absurd, absurd, absolutely absurd, absurd. Notice issue kijiye. We'll have to remand it. This is not 304. This is not 304. Perhaps this is not even 304 part 1. This doesn't fall within any one of the exceptions also.
Absolutely.
Bombay High Court? Strange. Dusty de dijiye.
Highly obliged. 31.1 is also connected.
Same.
Grateful.
Lordships put to me last time, it's a reduction of interest. And therefore, my lord, I want to answer 2 points.
Have we passed some order in the past?
No, my lord, it's a fresh matter. Kindly see page 7. My lord, my concern is this.
I have something to say, my lord. So day before yesterday, matter got listed. My lords directed them to file additional document because this
It's been
itself is
filed.
bereft of documents. Now they have midnight, my lord. They have filed certain documents. We don't have a copy.
Okay, Friday week.
Yes.
My lord, my apologies. It's a mistake on our part. It's a mistake on our part, my lord. My apologies.
Accommodating him.
That all right, my lord. My apology and to the bench.
Maybe served on.
We'll do. You should have filed it.
Well, I would like to also see these dates I made. It is blowing to smithereens 12A and my Lord Justice Padiwala's judgment a few days ago. It's smithereens. And if I'm exaggerating, your worship should not accept my submission. Just kindly see what is happening here.
That premeditation, sorry.
12A, Balas, that 12A. I mean, your lordship may repeal 12A if this kind of conduct. Kindly hand over the other one to my Lord Justice Padiwala. Just give me 2 minutes on this. No, just 2 minutes. I've had it made specially so it's faster, easier. Whereas I am petitioner, he is a respondent, he's fighting some iron ore. I've sold it to him, etc. That's the merit. That's not relevant. Just come to item 3. Does my lord have it, Malas? I, Malas, challenge a suspension of agency by the collector who stays it. I filed, Malas, in number 4, a police protection writ. Don't you got the number? Now the police protection is because miscreants, which means him, are against me. Malas, kindly follow that for a bit. It will be a little interesting to worship how you can avoid 12A. It's very extraordinary case. Then he files an IA number in item number 5, intervening in my police protection writ in item 5, which is 2024, March. That IA does not seek any stay, no urgency. I hope I'm clear. That is dismissed in Malas number 6, his IA. This is in March 24. On intervention IA without seeking a stay, because today he says, I want extreme urgency, 12A and give me stay. He doesn't seek any stay. His stay today, his stay is that I should not sell, touch or deal with the iron ore.
You should not.
I should not. This he could have sought from number 5. Just see 5.
What are your business relations?
My business relations is that I never agreed to sell to him. He has filed a specific performance suit. It's just coming in 2 minutes. Just bear with me. A lordship will be a little shocked about 12A. Now, Malas, my point in number 5 is that this the Lord author a judgment, but also will see how the judgment is blown to smithereens.
Dr. Singhvi, would it not depend on the facts of each?
That's the facts. These facts are the most perverse facts ever imaginable.
There is an urgency.
Yeah.
Court may assign reason.
Absolutely. No. So I start with number 5, where he could have sought urgency and stay. He did not.
One thing. Tell us.
Yes.
Exactly what is the dispute?
The dispute is a specific performance suit he files after 16 months of starting all this, in which he says that there is one exemption and one order 39. 2 things. The exemption is from 12A, his suit. He's the plaintiff.
He is seeking specific performance
Of an alleged agreement.
What is the nature of
by which I have to sell to him the ore.
You are procuring ore by mining? You are undertaking mining operations?
Yes.
So whatever you excavate, you have to sell that ore
to
him. That's your understanding.
That's the original suit for specific performance, which is filed 16 months after number 5.
Fine.
In that he says, I want interim injunction and waiver of 12A.
Your argument is
yes,
12A would apply if parties must go for mediation and resolve it.
Yes.
That's your argument.
And Malas, the argument is that 12A in the commercial court.
Now, if he is able to secure that particular relief which he is seeking, you may be able to excavate, but you cannot sell it to some other party. That is your problem.
He has got a stay after 2 years, pretending urgency about non-sale.
We are just trying to understand the implication.
So the stay is.
So either you have to stop the operations
or
you
not
don't
sell.
have to excavate.
Or not. Correct.
The entire thing over there only.
Correct.
That's the thing.
I'm grateful.
But y'all can't sit and trash it up.
Not for the reason, just whereas your lordship will just for even for more as an example of litigation, this is very interesting, not for this case. 5 minutes will be very interesting for your lordships. Lordship will decide whatever, because your lordship will not have seen these facts. Just bear with me for just 5 minutes by the clock. I've got this list and dates made for that reason. So item 5, he intervenes in my police protection writ, does not seek stay, seeks no urgency. Right, Bruce? 5 is March 24. 6 is his IA for intervention without a stay is dismissed. Then come to Malas, item 9. I'm not reading all of it, Malas. 9. He then attacks me asking the collector to recall the order. This is the second time he could have sought mediation or any interim relief. This is now in July 24. In item 10, he files another IA again for intervention without stay in my writ. Copy to him now. No, it's a review petition. His order is passed in review.
He wants to defend this on the premise that the suit still cannot proceed.
And that too.
Client of Mr. Subramaniam has not been able to get any order. No.
He got a stay. After a review petition, in a review petition against an order where he himself lost,
Okay.
which attained finality.
This order, you have not challenged further?
No, that is a merits order. I will challenge it on merits. I've still got 90 days.
Today,
I am only on 12A.
so your argument would be that because of 12A, his injunction application should not have been entertained.
Was dismissed. The trial court returned the plaint. Against that, after 1.5 years, he goes in a review. The review court doesn't have an application for stay, doesn't have an application for anything. In that review, IA, he files and gets an order contrary to an earlier order by the same court which had dismissed him, which he had not challenged. Give me one, these dates have to be seen. Whereas the Lordship will just spend less than 5 minutes, but Lordship will allow me to go on the. See.
31.7 is the return of plaint.
Yes, now so let's.
Spending in.
No, can I just kindly?
You got your point.
No, come to 15. Well, just one page will be left. Come to 15. Just say Padiwala may take number 15.
It is a suit.
That is his suit in which he has today now got a stay without 12A.
That is by the 711 order according to.
Yes, but Malas, this suit is filed after 16 months of the agreement, and it is filed, Malas, after all the earlier writ petitions where he's intervened over 1 year. Now come to 16. Returned suit. Returned the plaint. My lord has got, Justice Padiwala has got. Malas, one more thing. Your lordship in 12A has said it is not a formality. Everybody at 39. Then Malas, this order, they are important dates, Malas. 17, he challenges the FA. This is very, very important. My lord has got 17. My learned friend's suit is returned in 16. In 17, he files a first appeal. On 18, the order is reserved. On 20, the High Court rejects his interim relief. Would my lords double tick 20, Malas? Would my lords double tick 20? 14th of August, his interim relief is rejected. All this while he has not complied with 12A.
Points for you to vacate that 711 order or not, but then.
No, all this while it's not at 12A. Now just what he sees. In Malas, he challenges an item 23 by filing a review petition in 23. In this review, he has filed against an IA dismissing intervention. This is a little serious. In 21, he files yet another IA in my writ. Justice Padiwala may have 21 Malas.
Yes, Dr. Singh.
These facts are very important.
Come to paragraph 42 of the impugned order of the High Court.
Yes. Yes, Malas.
Just, let's read 41 also. We may note that by order dated so and so in review petition,
This court directed that status quo shall be maintained by order dated 9/1. So therefore, one is
By order dated by
permitted to withdraw the review. Liberty was granted to pursue its remedy in the present appeal, and the interim protection is extended. But that is why your lordship may leave this for a minute. Just trust me for 2 minutes. Just see the list of dates. Three dates. Then I'll not press it because Malas, this is not clear. Just bear with me, Malas. Your lordship got 16. My lordship Parivar has got 16. Your plaint is returned for lack of 12A. I hope I'm clear. Then Malas, he challenges it and orders for interim are reserved at 18. The very same interim he's got now is reserved at 18. My lord has got that? The judge.
But after it is returned, where is the question of reserve?
No, in appeal court. The trial court returns it. He goes to appeal. In the appeal, is reserved at 18. He is denied and dismissed in 20. Mark that very important, 14th of August. Dismissed. He does not challenge this.
In 24.
No, 20. That's the catch.
Give it the serial number.
Oh, no. Oh, I'm very for convenience, that's all. I should have said so. I thought your lordship.
Yeah.
No wonder your lordship might be disoriented if I'm saying. Well, it's 20 is in 14th August 24. I hope I'm clear, Malas. You have dismissed the interim application in appeal. You don't challenge it. Then, Malas, he files this is extraordinary, Malas. In 21, he files an IA 10875. In my separate writ, asking for protection. I hope I'm clear. This is my writ. This IA has no stay. It's only for intervention. That order of item 2020 and his IA is dismissed for intervention. He challenges that in item 23. For intervention, he challenges by filing a review. So it's a review of a non-intervention order. I hope I'm clear, Malas. In that order, High Court passes first and status quo. How? I'm asking myself in 24. No interim relief is sought by him. No parade. And it is passed contrary to 14th of August, where he has lost the main appeal. Now, 1 minute, Malas. He withdraws the review, para 25. Well, Alice in Wonderland, cursor is not the right word here. He withdraws despite withdrawing a review of a non-intervention, he gets an extension of status quo. I hope I'm clear.
Yes.
Then in 26, the status quo is second time extended. In what? In a review against a non-intervention. And then comes the impugned order on the next page. Now, Malas, bear with me, the errors. But this is, Malas, because your lordship has said, just turn to your lordship judgment for a minute. Barring 2 paragraphs, Malas, all of the judgment has to be seen. Kindly turn to your lordship judgment. Very recent judgment. I'm not citing it because Justice Padiwala is the author. It considers all the law at one place. It's called Dhanbad. Please give it.
May I?
No, just 2 minutes, Malas. Today I'm in appeal on a 12A. My lord has said what happens, Malas, when I file a suit. If I file 39-1, the law is not that every 39-1 is urgent. So why have 12A? Why have 12A, Malas? Your lordship has, Malas, punctured that theory in this judgment, which is blown to smithereens. Please see that now. Just bear with me for this. Kindly hand it over 2 copies. Just turn to para 62. He's try again. He gets some relief in a review. Does my lord have 62? May I? Please turn to my lord's conclusions at 62. Everything is summarized in one place. May I read with my lord's permission?
Yes.
Conclusion.
Read it.
The decision of this court in Patil is cited by the impugned order, lays down the correct position as regards 12A, holding it mandatory. 2. Para 104 of Patil, the declaration of mandatory nature relates back to the date of the amending act. 3. Para so-and-so of Patil, any suit which is instituted under 2015 without complying is liable to be rejected under Order 7. Not necessary here, but the lordship has gone that far. However, this declaration applies prospectively. We are a prospective suit for us. A suit which contemplates urgent relief may be filed without first resorting. No problem. Not in these facts. Then come to E. Unlike 82, leave of the court is not required. Forget that. So D is Malas general principle. E can be ignored. F. The test for urgent interim relief is if on the examination of the nature and subject matter of the suit and the cause of action, the prayer for urgent interim relief by the plaintiff could be said to be contemplable when the matter is seen from the standpoint. This man is going on from March 24. He gets this in 25, 1.5 years later. He can't go to mediation. Then, Malas, courts must also be wary that urgent interim relief must not be unfounded excuse by the plaintiff to bypass. My lord has used the word camouflage in the body of the judgment. Then even if the urgent relief ultimately comes to be denied, the suit may be proceeded with without compliance if the urgent is satisfied, notwithstanding the actual outcome of the merits. Now, Malas, the lordship is given I. This is very important. I. Suits without complying with 12A prior to August cannot be rejected under 7. We are not that, Malas. Come to J. My lord has got that? We are J. In suits without complying with 12A prior to 28, which are kept pending adjudication before the trial court, the court shall keep the suit in abeyance and refer the parties to time-bound mediation in accordance with section 12A, if an objection is raised by the defendant by filing an application. Thus the answer, now read 63 also, Malas. If the suit is instituted on or after the date of partil, without complying with 12A, it must meet with rejection either suo motu or by an application, even suo motu. Next, B. If the suit is instituted prior to 20 without complying, we are not concerned with that particular one. Having answered, we find it difficult to accept the contention. This is para 64 on the merits of that case. Trial court as well as the High Court committed an error in refusing to reject the plaint under 711. On the contrary, the approach adopted by High Court in the impugn order in keeping the suit in abeyance and referring the parties strikes a perfect balance between the mandatory nature as well as. Now, Malas, this list of dates starts in March 24. You have no time to do mediation. And you get an interim order after, Malas, I am sorry to repeat, I end in 2 minutes, Malas. After your lordships, why do you take away my paper? After, Malas, your lordship gets a refusal of interim relief in item 20. Just turn to 20. 20 is not challenged by you. Item 20. Advantage of his fruits of 12A violation. Just see 131. No, 1 minute, Bombers. 131. What is the application your lordship is facing? This is the way you exempt. 131. Just see, this is exemption he seeks. If this is so, I repeat, you might as well repeal 12A. 131. Annexure. Annexure? It's a paper book, page 131.
Dr. Simply, you first place that 711 order here in a review against a rejection of an intervention. That is when you place that order.
Yes, yes.
So that issue of
yes. After 1 minute, 131 will my lord see? Just for a minute, if your lordship doesn't mind. See 131 for just 1 minute in the main volume. The main volume, no? I mean, just see Malas, the main volume for 1. This is not the way you can get an exemption, Malas.
Yes.
131.
Yes.
Delightfully vague, one page, 1.5 pages. Filed a commercial suit. Craves leave. Prays the plaint will be kindly read. Went on dishonoring. Continually violating the agreement. Clandestinely transporting. This is happening for 1.5 years. Clandestine transport. Then, Malas, in case the defendant succeeds in achieving his illegal designs, forcibly ousting and unjustly enriching the lawful belongs to plaintiff, plaintiff will suffer an irreparable loss which cannot be compensated. Due to the urgent nature, please, Malas, give up 12A.
Now, where is the order on this? First order on this?
Yes, the first order on this, Malas, in the suit is 14.8. Come to page 34. I'm sorry, 223. 223. Apologies. 223. This is the first time. So, Malas, the first order is 166 when the plaint is returned.
319.
Yes. So, Malas, just for correctness, the first order is page 166 when the trial court rightly returns the plaint. I hope I'm clear.
After this application was filed.
Yes. It is it. Now he files an appeal. In appeal, the order he gets is 223. Show me 223.
You notice on payment of process fee.
No stay. Issue notice. There are 3 issue notices on 224. Turn the page.
Fine.
List after 4 weeks. No interim stay given.
Understood. Then what happens?
Then, Malas, he files an IA in item 21, keep my list of dates open, it'll be easier. In my writ for protection from police, this IA 108, page 34 of the second volume, page 34, is for only intervention without stay. My learned friend, Mr. Gopal Subramanian's client, seeks intervention in my writ for police protection, no stay sought. On this, Wallace, then he files a review petition at page 230. Turn to 230.
Annexure.
This is page 2, annexure number. Why don't you give annexure numbers here?
21. Annexure
P21. P21. 230. Now in this, Wallace,
This review is against which order?
against item 20.
Show us that order.
Yes, order is 223, page number.
P19.
Annexure P19. The one your worship just now saw, issue notice. Now against this, he files a review in an intervention application which is dismissed. Well, I'm sorry, I didn't show the dismissal. The dismissal is page 34 of the second volume.
So after P19,
Yes.
there was a final order of dismissal.
No, P19 was a notice.
Then what happened?
Then he filed Balas item 21 IA in my writ for protection, police protection, where the prayer at page 34 of volume 2 is of the IA is that please allow me to intervene. This order your lordship must read for 2 minutes.
Page 34 and P4.
The date of this order is,
Same date.
please, 14th August. There are two 14th August. My lordship may get confused. Second volume, additional documents. This is a very interesting order. The second volume.
7. P4. Yes.
So this second order, 14th August, in my writ petition, page 34, my lord has got. Now just turn it 34 straight away to, well, I'll not read the rest. The whole thing is summarized. So it's a detailed order. This fight is between me and the government about police protection. The learned judge had come to 46. 46. After hearing,
Yes, yes.
well, let's just see 8, para 8. During the course of arguments, learned counsel for the appellant, assisted by counsel for the proposed interveners, opposed. After hearing learned counsel, we are of the considered view, security is a dynamic process, leave that. Now come to 47, where he deals with Mr. Subramanian's client. Page 47, para 10. Page 47, para 10.
Yes.
Since the middle of that para, since the proposed intervener has already filed commercial suit, and after dismissal thereof, he has filed first appeal, which is pending in the High Court, after issuance of notice. Therefore, proposed intervener shall be at liberty to pursue its legal remedy in the pending appeal, which he did not challenge, Wallace, the other 14th August order. He never challenged it in Supreme Court or elsewhere. In the aforesaid pending first appeal, the enforcement of agreement by means of suit for specific, wherein the commercial code at the threshold of 711 has dismissed the commercial suit on the ground of non-compliance, etc. For the reasons recorded, this writ is disposed of, and then, Wallace, they dispose it of. So
Review in this order.
now in this, against this order, that I will not intervene you, Mr. Subramaniam, he files a review. That order is passed, Wallace, in review. Now just this review is important, Wallace. Turn to 230. 230 of the first volume. 230 of the first volume. Give me what I'm asking for. 230 of the first volume. There is no prayer for interim relief. Just turn to 230.
Annexure.
230, annexure P21. Well, I wonder if lordships have dealt with how many reviews of an intervention being denied. It's an extraordinary situation, Malas.
Right.
Very lawyer friendly, but very illegal. 230, he files this. And then, Malas, this is the whole petition. My learned friend has checked up. There is no application for interim relief. I mean, I can't show a negative. My lord will take my word. See the index. My lord,
Where is the final order?
now, on this, Malas, first order is page 50 of the second volume, the thinner volume, of the IA volume.
Why can't you all put it in a chronology? Additional main, additional main.
This creates a problem, Malas, but the thing is that
How many times we have to keep switching over?
just keep 2 volumes only. Well, I'm sorry. On this, the order passes 50. No, you have to put in the same SAP volume.
In the additional.
Yeah, in the second volume. Only 2 volumes. P5.
P5.
Now, in this, Malas, which is in a review of an intervention, the court is saying file reply, etc. And last sentence, without any reason,
What did you do with
at
this?
page 57,
But what?
page 57,
Got it, got it.
he withdraws this. My landlord withdraws it. Come to that order at page 58 of volume 1. I'm very sorry to.
So with the withdrawal, the order of status quo also goes?
No, I withdraw, but extend it. Then he goes to that, the first appeal and gets the impugned order. Well, and all this is without 12A. Well, at the moment, I'm not on merits. Will your lordships allow with this application of exemption of two lines?
Now we have understood. Yes.
Lord, may I? My lord, would your lordships kindly come to page 204, my lord?
With all due respect
Yes.
to the two learned judges,
Yes.
we don't approve.
My lord, may I just give a little context if your lordship does?
We smack off something very foul in this.
Try.
My lord,
Very foul.
my lord, may I?
That's the feeling. Unfortunately, we have gathered. Issue notice. Who is the AOR? Who is the AOR?
Mr. Amit Sharma, my lord.
Learned so-and-so, the advocate on record, waive service of notice for and on behalf of the respondents. Huh?
He's one.
One respondent. So
Respondent number one. Who is respondent number two? Who are the other respondents?
Individual ex-directors are all the other respondents. Some support me, some support him.
Give them dusty so far as.
Yes,
others
we'll
are
take
concerned. Right?
Well, stay of page 15, para 43.
my lord,
Stay of
may I-
page 15,
may I
para
make
43.
one submission, my lord, on that.
He cannot enjoy the
My lord,
benefits
may I
of his
make
law.
one submission on that?
Not be, are we not granting you the final relief?
I'll tell you why not. For 1.5 years, he did not have para 43 at page 15. So why today, Malas, he has got it by repeatedly going round and round.
Thoroughly understood. No doubt about it. Thoroughly understood.
My lord, I
Malas,
have
your
one
lordship is not bound by something which he goes and gets surreptitiously after 1.5 years without going 12A. If Malas, nothing happened for 1.5 years, why could he not have got this?
May I speak? May I read this? Or may I make one submission? My lord, under the contract, he was supposed to supply me with 170,000 tons of iron ore.
Sir,
And I have paid the money, my lord.
sir, we are not going to touch your contract. Whatever may be the understanding between the parties, if each party is obliged to abide by
True, my
it,
lord.
they have to. But what has been highlighted is something which.
My lord, the
Unprecedented.
injunction which he is
In-
appealing against is only to preserve, my lord, my rights under the contract. Your lordships refer to
The
paragraph
bench
47.
takes that order in review and passes this.
No, my lord. My lord, just give me one moment. My lord,
Shocking.
my lord, I need to offer some explanation, my lord. My lord, one explanation is, my lord, what he did was, after the agreement was entered, I paid him 1 crore of rupees the very next day. In terms of the agreement, the ownership of this 170,000 metric tons of iron vested in me. In order to, my lord, defeat my rights under the contract, he filed successive writ petitions in the High Court, seeking various so-called protective orders and of police protection to enable transportation of all this iron ore elsewhere.
No original agreement, we dispute the agreement. So 24 till now, he never had it. Why should you have it now? He did not have any protection from March 24 till August for the first time he got.
Would you
And
all
no,
like-
no reason given here. No reason given here.
we have a proposal. Would you all like to go before any arbitrator and resolve it? Tell us. We'll send you all to a good arbitrator.
See, no one gets
Talk,
dismissed.
finished it off.
Dismissed, get dismissed. Well, he has filed criminal actions against me.
We'll take care of it.
That has
That
to be.
will take-
Then I think yes. Or a good mediator also, well, if
Sir?
you would want, Mr.
Will your client agree?
Well, I'll persuade my client.
But
I'll persuade my
You're getting something you want to.
So no suit, nothing, no suit, no 12A, everything will go.
But well, criminal must go, Malad, because he is filing left, right and center and writing to the collector, stop me.
But my lord, I need this quantity to be protected.
Parties to maintain status quo.
Great.
Both sides will maintain status quo. Both sides.
No, in all proceedings, Velas. In other Velas, because all this is, he is filing so many criminal matters.
Parties are directed to maintain status quo as on date. If there are any other criminal proceedings,
There are.
with the parties, all those proceedings shall also remain stately. Are you agreeable, sir?
My lord, I am agreeable. I want this contract, but
Okay.
it's only about a contract.
Okay, will you
I have
name
paid
an
the money.
arbitrator? Come on, name one arbitrator. Sole arbitrator.
That is part of the arbitration.
We'll put an end here only, today itself.
Well, our case is that he doesn't have the original of the agreement at all. So it all will go before the arbitrator. Why do you repeat?
That's a different thing.
Yeah, that's a merit for us. My lord is right. Give a name.
But the next day, 1 crore went in a bank statement.
Give a name. Well, it's a. State the order, leave the name blank. Somebody will come and tell the court master. Well, just, I don't want to take it without there. Otherwise, anybody, well, it's retired learned judge of the Supreme Court, sole arbitrator. Give a name, any name. I forget the name, so retired now.
What are the stakes involved here? What are the stakes?
According to us, the agreement is not an original, not signed, not produced. Therefore, well, the stakes are, for me, well, my entire mining will be stopped.
So should
Stop.
it be
There was a claim for specific performance.
Mediation is better, Malas. Mediation is better because that was the intention. And thereafter, Malas, we'll go into the suit. Then let this 2 points, Malas. Let the majesty of the law be followed in 12A. Malas, let the majesty of the law be followed in 12A. That will be done through Justice Kurian Joseph, through Mr. Panchu Gopal, anybody your lordship likes to nominate. And it will be hardly, Malas, 8 weeks, etc.
Mediation.
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 And that's right. That will comply with 12A also. The matter will be over either way.
We'll appoint Justice D.Y. Chandrachud, Dr. D.Y. Chandrachud.
Certainly.
Former Chief
Certainly.
Justice. Should we pass the order?
Yes. Yes. Mediation. Lordship, we use the word mediation. Can't be given. You preferred it. You can't say.
And my lord, may I implore that your lordship's order status quo ante. Great.
What will you sell it with?
This petition arises from the order passed by the High Court of Madhya Pradesh.
Give us via media that you will
at
not sell something.
Jabalpur, dated 11th of August
Give us via media that you will
2025.
not sell something till the date of the mediation.
In first appeal number 1050 of 2024,
May I take your lordship leave this?
by which the appeal filed by the respondents hearing against the order dated 31/7/2024 passed by the Commercial Court returning the plaint filed by the respondent number 1 herein came to be returned on the ground of non-compliance of Section 12A of the Commercial Codes Act 2015. This appeal, this petition Against the order dated 31/7/2024, returning the plaint on the ground of non-compliance of Section 12A of the Commercial Codes Act 2015 came to be disposed of with appropriate direction. Full point. The High Court, while disposing of the first appeal, observed as under paragraphs 42, 43, 40, and 40 respectively. Okay? The petitioners being dissatisfied with the impugned judgment and order passed by the High Court are here before us with the present petition. We heard Dr. Abhishek Banu Singhvi, the learned senior counsel, appearing for the petitioner. Original respondent number 1 before the High Court, and Mr. Gopal Subramaniam, learned senior counsel, appearing for the respondent number 1 hearing, original appellant before the High Court at length. Manifold contentions were sought to be raised in the course of the hearing. By both the sides. Good. Having heard the learned counsel appearing for the parties and having gone through the materials on record, we are of the view that this long drawn litigation between the parties, which is getting murkier and murkier day by day, could be brought to an end if parties are persuaded to go for mediation before a former judge of this High Court, before a former judge of the Supreme Court. More particularly considering the nature of the disputes between the parties and the stakes involved therein. Full point. The proposal put forward by us for mediation has been very graciously accepted by Dr. Abhishek Manu Singhvi and Mr. Gopal Subramaniam. In such circumstances, we appoint. Dr. Justice D.Y. Chandrachud, former Chief Justice of India, to act as a mediator between the parties and resolve the disputes. Full point. The fees, etc., of the learned mediator shall be fixed in consultation with the parties. The learned mediator shall furnish his report at the earliest. Okay? Parties to appear before the learned mediator and proceed further. This matter for appropriate directions after 8 weeks. Okay? In the meantime, both the parties are directed to maintain status. If there are any proceedings between the parties, civil or criminal, Those proceedings shall remain stayed till the report of the mediator is received. And further orders are passed by this. Okay?
Very well.
Sure, proceed.
Deeply obliged. My lord, just one more thing, my lord. There are certain civil cases not filed by respondent number 1, but by some other group company, my lord, against the petitioner.
We are sure now it will be resolved.
Very well, my lord.
Fine? Something, it was little distant.
Lordships had,
Anyways,
my lord, acute discernment.
anyways, doesn't. Next time.
Deeply obliged.
नहीं, अपनों respect. Rest of the matters, we will post it in the next week. We have a separate bench.
Lordship.
Any mentioning?
Your
44, service is incomplete vis-a-vis 2 respondents is concerned. So
Whatever request you all have to make it to the.
in the meanwhile, I'll do that.
Your Lordship, I am mentioning item number 46, Your Lordship. It's an urgent matter, Your Lordship. NEET PG matter. Monday, Your Lordship. Lordship, top of the board will be.
Who is appearing for the other side?
Your Lordship, NB.
Who is appearing?
Minal Sharma, Your Lordship.
Respondent, NBMS Lordship. I'm the.
This is the same matter where Mr. Rahul Kaushik.
Yes, Your Lordship. Yeah. Your Lordship, these are Rahul Kaushik sir, this is a connected matter.
Connect.
Main is the Aditi and others, and
We'll keep it on Tuesday, not Monday. Tuesday, top of the board.
oblige, Your Lordship.
My lord, may I mention item number 36, my lord? It was related to the illegal arrest, my lord.
Illegal?
Arrest, my lord. Yes, yes, my lord. Chinese woman has been arrested and 3-year-old child. Today the matter was listed, but it was not called.
You have served them?
Yes, yes, my lord.
Who is appearing?
I'm being led by learned ASG, Ms. Bhati Lordship.
Party has some instructions.
Yes, yes, Lordship.
What are the instructions?
Previous order.
What are the instructions?
When I'll inform her, she'll be here, Lordship. After lunch.
But after lunch, we are not assembling.
Maybe on Monday, Lordship.
You asked Ms. Bhati to be here on Monday. Monday, top of the board.
Yes, Lordship.
Monday.
Can we have your lordships?
1 to
May I
10
have-
list.
Item number 1.
Oblige, my lord.
Mr. Pardue.
May I have your lordships?
There's one matter, serial number 41. Would be taken up on 17th October, if it's convenient.
17th.
October. Or next Friday also, I have no problem.
17th October.
Or next Friday, whatever is convenient.
Your petition case.
Departments.
Department's petition. Okay, we'll fix it.
Obligement.
Would your lordship be item 37, my lord?
Yes, what do you want to mention?
My lord, item
Hello?
37, can it be on 6th of October, my lord? I'll be coming to Delhi on that day, my lord.
Pardon? Pardon?
Item 37, can
Uh-huh.
it be had on 6th of October, my lord?
6th of October.
Yes, my lord.
Okay, 6th October. Okay.
Oblige, my lord.